Welcome to our our show today. The Termination, examining an employment decision gone horribly wrong. Um, this tale is it's a true tale ripped straight from the headlines, actually ripped from the reported cases of the 10th Circuit Court of Appeals based in Mile High, Denver, Colorado. But today, our own version of the definitely not ready for primetime players, Teresa Schulda and Jeff DeGraffenreid, will hopefully educate and questionably entertain you with a dramatic retelling of the facts in a case called Dixon versus the Regional University System of Oklahoma. My name is Sarah O'Keefe, and I will be your narrator. Okay, now also, please note, none of the characters in this dramatization are based on real people, but you may spot some of Jeff's tendencies to channel his favorite television detective of the 1970s, 80s, and 90s. And also, fun fact, I did check IMDb, and actually there was a Columbo episode in 2003, special made for TV movie. So, anywho, the rumpled but shrewd Lieutenant Columbo. If you're as old as Jeff, which I am not, which is why I had to Google it, you will no doubt remember the classic cigar chomping Peter Falk character, complete with a brown suit and tie and a wrinkled tan overcoat. We will call Jeff Lieutenant Jeffumbo. And Teresa will be playing the role of a representative from the defendant in this case, a college based in Oklahoma. So the facts that we present here are based on the facts as they were set out in several of the reported decisions in the case. What you'll see are Jeff and Teresa presenting 3 acts. Now, in the first act, what you'll see is some basic background about the case and some of the primary parties involved. In the second act, we'll talk about the plaintiff's complaints and the beginning of the investigation into those complaints. And then in the final act, they will focus on some of the facts the 10th Circuit found compelling enough to essentially revive the employee's case that the federal magistrate judge in Oklahoma had actually originally thrown out. So when we talk about real cases, we typically do only have the information available to us from the published decisions, and that's true here. So these facts are largely taken straight from the court's reported opinions. Because we believe the Court of Appeals focus on the details of the investigation and the notes that were taken during some of these meetings, this case is one that provides a lot of great lessons learned for us. And we think there'll be great lessons learned for you as well, things you can implement as you field and investigate employee complaints. We hope to provide all of this to you in at least a mildly entertaining way, but no promises. Between acts, I will jump in and provide some context, background, and I'll ask you to think about what you've seen. As we move through the story, obviously think about the frustrations and pressure that HR professionals involved in this case probably felt, and then also consider how you might have handled things differently. There are several opportunities to identify there. Now, for dramatic purposes, let me set the stage. Lieutenant Jeff Umbo will be interviewing / investigating someone from the university. Now, over to the players.
Good morning, madam. I'm Lieutenant Jeff Umbo, HR Police, Homicide Division.
Wait. Homicide? When I got my SHRM certification, there was nothing related to murder, so a little concerned about this. I just
Let me be frank, madam. I only said that for dramatic effect. We won't be talking about homicide. I just wanted to lighten the mood. Did it help at all?
No, not funny. Not funny.
Well, then let me start over. Let me ask you, madam, do you feel like you're up to speed on the case, that you know the facts well enough to be interviewed here today?
So I wasn't involved in the case. I want to make that clear. Nothing that happened because of me, all right? So I wasn't involved in the case, but I have read all of the underlying court cases, and I will certainly do my best to answer your questions.
Very good, madam. Now, let's start with some of the key players in the case. The first is a former employee, Miss Walking Stick Dixon. Do I have that right?
You have that right, Jeffumbo.
And Miss Walking Stick Dixon is a Native American woman of the Cherokee tribe and female, correct?
Yes, that's what a woman is. A woman is female, and she was also Native American.
Thank you. Now, tell me about Miss Dixon. Just tell me about her.
Well, Miss Dixon worked for the university in the information technology department.
Do you know how long she'd been there, ma'am?
I do not know. That did not come up in the court case.
But you know that she'd been there at least 3 years, correct?
That sounds about right. She was there for at least 3 years, and that entire time she reported to the esteemed Dr. Reef.
Yes, we'll talk more about Dr. Reef. And how was she as an employee?
What do you mean, how was she as an employee?
Well, for example, was she good at her job?
Yeah.
Okay, madam, I'm used to hearing vague responses from suspects and the like, but I'm not sure exactly what to do with me. I mean, is there anything that you could look at to tell me how she was at her job?
All right. Well, she left the university in 2018, and we know she was there for 3 years. So if I look back through the documents I have, 2015, 2016, 2017, yeah, her performance evaluations, they were meh. They were so meh.
I see. So she did have performance evaluations. I'm not exactly sure what meh means. Are you saying she just didn't meet expectations?
No, I didn't say that, Jafumbo. I didn't say she didn't meet expectations. There were some good things about her performance and then some not so good things about her performance. Meh.
Okay, I'm still not sure, but so what did the performance evaluations tell us about Miss Walking Stick Dixon?
Well, they told us that her manager, Dr. Reef, the esteemed Dr. Reef, he, in each of those 3 years, he marked her as meeting expectations. Okay. And he also noted that she could have done some things better. She could have done some things better.
I see. I think I understand. So the manager could have indicated that she wasn't meeting expectations, true?
I mean, the manager esteemed Dr. Reef. He could have done whatever he wanted to. So yes, I assume he could have marked her as not meeting expectations if he wanted to. But he didn't do that. He marked her as meeting expectations, and he listed some things that she could have done better at.
Some things she could have done better at, some things she did well. True?
True. Some things she did well, and some things she could have done better.
And at the end of the day, he took the performance evaluation and he marked the box that said meeting expectations.
That's right.
Very well. Now, ma'am, as I understand it, January 2018, Miss Walking Stick Dixon raised some concerns to the university about her manager's comments in the workplace. Is that true?
That is right. She did go to our Title IX coordinator in January of 2018 to share some concerns about the esteemed Dr. Reef.
Well, as HR police, I've heard of Title VII. Title IX. Can you tell me a little bit about that?
Well, at a very, very high level, Title IX is the civil rights law that applies to schools and institutions of higher education, like our university, which you probably can't see, but we're called the University of Learning. Title IX requires us to treat both students and employees without regard to protected characteristics. And when it comes to the employment part of Title IX, it's very similar to Title VII, and it prohibits discrimination on the basis of race, sex, those kinds of protected characteristics.
Thank you, ma'am. That's very helpful. Now, let's walk through those concerns that she had. Tell me about those.
Well, she said that when she first started, the esteemed Dr. Reef asked her about the origin of her name, Walking Stick.
Now, why would he do that?
I don't know. You're probably going to have to ask the esteemed Dr. Reef why he did that, but maybe he was just curious about where Walking Stick came from.
Fair enough. Anything else?
Well, after a meeting, according to Miss Walking Stick Dixon, the esteemed Dr. Reef asked her if he could use her notes as the meeting minutes for the meeting. So apparently Miss Walking Stick Dixon would take notes during the meeting, and Dr. Reef just wanted to use those notes as the meeting minutes. And she said no. She refused to let him do that.
Why did she say no?
Well, she thought that assigning her a gender stereotypical role, like being the secretary of the meeting, was not something that she wanted to put up with. And so she said that it wasn't appropriate, and she refused to do it.
And I understand she also said something about the chief of the Cherokee Indians in that area.
Yes, she said that the esteemed Dr. Reef had made a comment about the chief of the Kiowa band of the Cherokee and accused the chief of being slow, not very smart, and not a good leader.
Okay. Anything else that was said?
Okay. Anything else that was said? No. Yes.
Anything else?
Yes.
Anything?
Yes. So she claimed that Dr. Reef said one time, "Oh, you're in a good mood today. Your husband must be out of town." And he also said that the girls in the office should take care of planning and coordinating office parties. She was upset about those comments as well.
Sounds like some episodes of Columbo from the 1970s, and also a little like Michael Scott's office party planning committee.
Well, I guess so. Maybe she didn't want to be the Angela of the office with regard to the party planning committee.
I understand. Okay, so she told the Title IX coordinator all of these things in January. So what happened?
All right. Well, she made her complaints to the Title IX office, and she said things got better. She said the esteemed Dr. Reef got a little better, and she was okay after that.
Fantastic, ma'am. Fantastic. I guess that's the end of the story.
Well, unfortunately, no.
So tell me, what happens next?
So in March of 2018, remember, she made her complaint to Title IX in January of 2018, and a few months later, she called in sick for 2 days, and she claimed that she told the esteemed Dr. Reef that she wanted to report those 2 sick days as comp time because she had worked 30 hours over the spring break.
I see. Then did Dr. Reef agree to that?
Well, according to Miss Walking Stick Dixon, Dr. Reef said okay and shrugged and walked away. But let me tell you, Dr. Reef denies that he okayed those 2 sick days as comp time.
I see. Now, did she go ahead and report those 2 days as comp time?
That's what she did. She reported them as comp time. And oh, go ahead.
Go ahead, madam.
Well, she did, but then when Dr. Reef saw that time report, he told her she couldn't report those sick days as comp time.
Okay, and so then what did she do?
Well, she fixed it. She went back in and fixed it and marked those days as absent and not as sick days and not as comp time.
Ah, I see. And that was in March.
Yes.
As I understand it, ma'am, that was not the end of the story either, correct? Because as I understand it, that's the beginning of the story. Now let's turn to May 4th. And that's a pretty important date in this case, isn't it?
It's when Star Wars fans all over the globe celebrate.
Is there any other importance other than Star Wars?
Okay, yes. I think in this case, it's the day that Miss Dixon's manager, the esteemed Dr. Reef, gave her a formal written notice for a falsified leave report. And she responded by filing a formal complaint of discrimination after she got that formal written reprimand.
Let me see here, ma'am. You say, I want to make a note of this. You say falsified leave report, correct?
That's the way the University of Learning refers to it.
I see. And so you've always referred to it like that. Let me just ask you this, ma'am. Let's take a look at the note that Dr. Reef sent. I think there it is. Yeah. Now, look through this, ma'am, and give me the highlights here.
Well, it says if you refer to my last month's leave report, you did when you filled out last month's leave report, you did not use vacation or personal days for the 2 days you called in sick.
Yes.
And he acknowledged that she worked over spring break, but he wanted to remind her that exempt employees don't get comp time.
So no question, she worked over spring break.
No, that's correct. No question.
All right, please go on.
And then he pointed out that there is a very informal and undocumented practice at the University of Learning of granting comp time in unusual circumstances, but only at the supervisor's discretion and only with prior approval. He pointed out that she had not gotten his approval for her submission on the leave report, and that she was very well aware of the rules.
I'm sorry, madam, just to clarify, the good doctor here says, and I think you agree, that did you have a formal documented practice on exempt comp time?
No. Dr. Reef said it was apparently very informal and undocumented.
Those are always the easiest sorts of processes to follow. I kid, madam, I kid. Please proceed, ma'am.
So again, he pointed out that she was very aware of the exempt versus non-exempt leave policy and that she was not exempt from the same rules that she was in charge of enforcing. And he wanted to make sure she understood that the email constituted an official reprimand.
Official reprimand. And now, madam, you've been referring to this as a falsified leave report. Can you just show me where the manager used that term?
You know, I think he must have just left it out of this email, maybe.
I'm sure that's it. All right. Now, how did Miss Walking Stick Dixon respond?
Well, that very same day, May the 4th, she filed a complaint. In an email back to Dr. Reef, she copied the head of HR and Title IX, and she claimed that her working environment was upsetting because her manager supported different practices for different people, and she felt like she had been singled out, and she complained about racist and sexist language that Dr. Reef had supposedly used, and she asked for a formal investigation.
Thank you, ma'am. And did the university investigate?
Yes, we did investigate.
Okay. So that brings us to the end of Act 1. Let's look at what we have learned so far. We have Walking Stick Dixon, who is a Native American female working in Oklahoma at the University of Learning or some other institution. In January, she did complain to her Title IX office about comments her manager made that she thought were inappropriate. And she was officially reprimanded on Star Wars Day for taking comp time without approval. She immediately then files a written complaint of race, gender, and hostile work environment in response to that write-up, and she requests an immediate investigation. Okay, so this probably sounds to most of you like just another day at the office in terms of the sorts of complaints that maybe you see. Maybe they're not quite as egregious. But I'm guessing that at this point, most of you would generally recommend that you investigate the complaints, right? In Appoint a neutral, unbiased investigator to promptly initiate an investigation, to interview the parties involved, to interview the witnesses, and then to reach a conclusion and perhaps follow up with the employee about the results that the investigation found. And then you all know there are several outcomes, right? So the complaint may be unsubstantiated. There may be some coaching involved for the manager about being a little more sensitive in the workplace, or could be that the complaint could be substantiated. I mean, maybe the esteemed professor says, yeah, that's right, I said it. Right? Any kind of outcome here if there's an actual investigation. So what you may have guessed at this point is that that didn't exactly all happen here. So let's turn back to Lieutenant Jeff Umbo and Teresa to see what did in fact happen next in this case based on what we know from the court opinions.
Thank you, Sarah. Let me just say, there have been some questions in the chat and about Jeff Umbo's beard and whether he ever trims it. Of course, part of my look is to be rumpled. So no, I never trim my beard. And that's part of my allure. All right, Teresa, let's keep going here. Now, I assume that you had investigated at this point and that you did so in a timely fashion.
Well, we investigated.
I see you hired investigators from the university. They interviewed the employee and the manager and did all of the things that we would always recommend that people do in this situation, correct?
Sure. Yeah, sure.
Very good, madam. And tell me, when did the interview start?
July sometime?
July. Tell me, madam, was it at least July of 2018?
It was, yes. Okay, Jafumbo. It was at least July of 2018.
Excellent. Well, the complaint was in May, correct?
Yes, it was.
And you waited until July. Tell me, what happened in the interim?
Well, the employee took FMLA leave after she made that falsified leave report.
Ma'am, I'm sorry. You keep using this term, falsified leave report. I guess we'll just come back to that in Act 3. But let me just ask you, when did she take this FMLA leave?
It was early to late June.
Very well. And when she came back from leave and she spoke with the investigators, what did they tell her? What did she tell them?
Yes. Well, she repeated her race and gender complaint, and she provided some additional examples of what she claimed was harassing and discriminatory treatment.
Fair enough. Can you share some of those with us, ma'am?
She said that the esteemed Dr. Reef had said, let's have a powwow. He also said, and I'm a lady, so I don't like this language, but she claims that he said, let me be the dick and take this to the team. And he also supposedly said to her he didn't want her on the warpath.
How did the manager respond?
Well, the esteemed Dr. Reeve sent a letter to the investigators and wrote that he found the allegations of sexism and racism insulting to his very core. And he asked if he could file a complaint for defamation of character against Miss Walking Stick Dixon.
So from an investigator standpoint, this sounds like a classic he said, she said situation going on here, ma'am? Tell me, what were the results of the investigation?
Well, on August 16th, we fired Miss Walking Stick Dixon.
Oh, you didn't fire the manager.
No, we fired Miss Dixon.
Well, I must say, ma'am, that's a little bit surprising. Can you just tell me why?
Well, the termination letter very clearly tells us why. It says that the University of Learning noted Miss Walking Stick Dixon had a negative attitude towards new projects. She had a poor reputation, and her poor reputation and attitude had given the entire IT department across campus a bad reputation. Her failure to provide projects in a timely manner, that also stacked up in there. Her division's backlog of tickets was a reason. And she also, remember, she failed to properly report her time off.
And was that the main reason that she was discharged?
Well, during depositions, a member of our HR team said that the timekeeping issue was the main reason she was fired.
I see. And one more thing, ma'am. Did you hire a replacement for the employee?
We sure did.
Well, that certainly took a turn. Sounds like Detective Jeff Umbo hasn't exactly gotten to the heart of the matter just yet. So let's review what we just heard. We know that investigators were assigned, right? What we don't really know, though, is who investigated. So we don't know if this was an HR investigation or if this was an investigation done by the Title IX office. We also don't really know whether the manager himself was ever interviewed, right? So we know that the plaintiff was interviewed, Ms. Walking Stick Dixon. So investigators did meet with her. And it looks like they may have just relied on the manager's letter as his response to the complaint. And I will note the court doesn't make as big a deal about it here, but generally we would say that gap in time between the complaint at the beginning of May and the investigation sometime in July was not exactly the prompt investigation that we typically recommend. So the 10th Circuit doesn't really focus on that in the ruling, but we would like to point that out to you all. Okay, the court, however, does ultimately focus on some other activities that were happening behind the scenes that ultimately seem to have led to the decision to terminate this employee. So let's return to the still not ready for prime time players and find out what happened next.
I'm sorry, madam. You surprised me a little when you said that the employee was fired. So let me turn back to my notes and ask you a few questions about what else might have been going on. Now, I've heard you use the term falsified leave report a few times. Is that correct?
Yes, falsified leave report.
And we didn't see that in the manager's notes, but when did you first begin to use that term?
Well, I'm not sure, but it was sometime after that May 4th complaint.
I see. And why would you refer to it in that way?
Well, HR started looking into Miss Walking Stick Dixon's prior leave, and they found 2 other instances where she falsified her leave.
Now, these other instances of leave falsification, that didn't have anything to do with her complaint, correct?
Well, not exactly, but the university must have determined that it was relevant to the overall issues.
I see. Now, again, this violation of a leave policy, this is the one that the manager described as informal and unclear, correct?
Well, Jeff Umbo, I thought the detectives were a stickler for the facts. He described it as very informal. But yes, you're correct.
Thank you, madam. And I understand that that other employees described it as unclear, arbitrary, and unenforced. Is that right, ma'am?
Well, yes, I think that is right.
And at least some testified that this discipline that Miss Walking Stick Dixon received was considered a very low level discipline, correct?
It was a written reprimand, which, yes, it's at the lower end of our disciplinary scale.
And just one more thing, ma'am. Possibly one more. Isn't it true that the employee testified in her deposition that comp time in IT was common because so much work was done on weekends and after hours?
Well,
And one more thing, ma'am. Let's talk about some notes that I've seen. I'm seeing some notes from a meeting that occurred on July 23rd at the office. Are you aware of that, ma'am?
I am.
I think let's just walk through these notes here. It says at the top, it says Marcy Walking Stick leave discussion. And then someone wrote below that, discussed key employee. Marcy does not fall into the top 10% of employees based on salary. Ma'am, do you see that?
I do.
And do you know what a key employee is under the FMLA?
Well, Jafumbo, if you knew me at all, you would know that the FMLA is my jam. So
Excellent.
yes, I do know what a key employee is.
Can you tell us what that is, please, madam?
Well, a key employee is an employee who is among the highest paid 10% of all employees employed by the employer in the region that you're looking at. And in some cases, you do not have to reinstate a key employee after an FMLA leave because they're so important to the organization. That's why they get paid so much money that you can't do without them for the leave. So that's what a key employee is. And of course, the FMLA tells employers that they must identify key employees at the outset of the leave, not once the leave is concluded.
Now, madam, would you agree with me? That being said, a person might look at this July 16th note and conclude that there was a discussion to determine whether or not you needed to bring back the employee after she completed her leave.
Well, I guess that's one way to look at it.
Okay, ma'am. Now, just one more thing. I see there's some other notes here as well. Let's talk about those. These are dated August 15th, correct, ma'am?
Yes, that's correct.
All right, let's walk through these, ma'am. Can you just explain to me what these notes say?
So at the top, there's a bullet point that says plan, restructure, reduction in force.
Plan restructure.
Then there is a bullet point that says false claim hyphen term.
Yes.
And then a bullet point that says theft of property, emails, etc. False claims. And then there's a bullet point that says, can we show copy or performance gross? Delivery to home emails, falsification of records. Can we find evidence of gross misconduct on L Drive?
Now, I see there's some other things at the bottom there, ma'am. What do we have here?
Well, there was a separate page of notes that said leadership, backlog of tickets, falsification of leave records, customers refusing to work with, attitude towards customers, refusing to change user IDs to reflect legal name following divorce from abusive spouse, and then finally, there was a note that said 8/16/18, 2 o'clock.
Well, let me come back to that date because I think that's important. Madam, as I understand it, Miss Walking Stick Dixon was hired back, true? Or what was her position was replaced?
That's true.
There was no reduction in force. Is that right, ma'am?
There was no reduction in force.
There was no allegation of theft of property, for example, emails. Is that true, ma'am?
Well, I guess they couldn't prove it.
Yeah. And did you go out? Do you know, ma'am, if you went out and tried to search the drive to find evidence of gross misconduct that just didn't apply?
Well, they might have done some poking around.
Ma'am, let's turn back to that date there at the bottom of the note. 8/16/18, 2 o'clock. Can you remind us, ma'am, when Miss Walking Stick Dixon's employment was terminated?
August 16th, 2018 at 2 o'clock.
Thank you, madam.
Now, if Detective Jeff Umbo seems suspicious, just know that that suspicion was shared by the 3-judge panel from the 10th Circuit Court of Appeals that ultimately found the notes from HR tended to show what you might hear lawyers call pretext. Now, pretext really just means not true. These notes were basically evidence that the lawyer or that the company's reason for terminating Miss Walking Stick Dixon, there's a real good chance it was because of her complaints or her FMLA leave. So when lawyers argue about whether summary judgment should be granted, a lot of times we use the term pretext. So essentially what this means is that the employer's stated reason for a termination, in this case, the write-up for the timekeeping issue, it just can't be believed. It just doesn't, it does not ring true. So what the courts say is that plaintiff must demonstrate that the employer's justification is pretextual. And if the plaintiff can show that, they can really get past summary judgment, and you're talking about going to trial, which, as you all know, is very expensive, very time consuming, and very risky. So ultimately, what we're seeing is what were the true reasons for the employer's decision? So pretext can generally be inferred from things exactly like this. Evidence that reveals weaknesses or implausibilities or inconsistencies, notes that say, well, maybe we can find something on, the drive to terminate her. And well, maybe, can we argue that she can't come back from FMLA at all because she was, a key employee? So notes like this in this case were some pretty solid evidence in the court's mind of pretext. So the court noted that the July 23rd notes about the key employee permitted a reasonable inference that the defendant wanted to fire the plaintiff before it even investigated her discrimination complaint, right? The notes were written 4 days before the investigators even interviewed Miss Walking Stick Dixon about her complaint. It also found that the August 15th notes demonstrated weaknesses and implausibilities and potentially improper discriminatory reasons for her termination. So the notes list these reasonings, right, for terminating someone. Presumably they wanted to say, Miss Walking Stick Dixon was falsifying records. Were there some performance probably gross misconduct, gross performance issues? And the notes ultimately included these concepts of, let's just call it a restructuring. Let's say it was a reduction in force. All things that ultimately were not used as the reason, but it clearly shows in the court's mind as well as mine, and I think probably Jeff Umbo's and Teresa's, that obviously these people were just looking for some justification to terminate this woman. So what the court does ultimately is send this case back to the district court, and finding that there was enough as evidence to allow a reasonable juror to infer that these notes were essentially grasping for reasons to fire Ms. Walking Stick. And that last bit was a quote from the actual court. They were grasping for reasons to fire her. Okay, so I'm sorry to say that's the end of the performance portion of our show. But let's take a few minutes just to talk about what lessons we can learn and have learned from this case, or some handy reminders. Teresa, would you like to start us off?
So one thing that I was struck by in this case what is HR's role? And so when you read this case, and again, I just want to caution everyone that we presented the facts from this case as it was reported by the court. And Jeff's going to talk about this later, but when the court presents the case in their decision, they are giving the employee plaintiff every benefit of the doubt. So they're presenting the facts in the case that the plaintiff is most favorable to the plaintiff. So we really, honestly, we do not know what the true facts are here. But the way the facts were presented in the court decision, what it looked like was that HR was doing the dirty work. They were doing the dirty work, probably at the request of the administration. But they were digging and digging. They were going into that hard drive, trying to find the dirt. They were looking back, scrolling through her leave record historically to try to find some other situation where she might have claimed comp time that they could hang their hat on. And they were doing that dirty work. And it made me think about when I talk with my HR clients about what the role of HR is. And you guys are often caught in this rock and a hard place between trying to make sure that the employees get the benefits and the terms and conditions that they signed on for, but then also making sure you're enforcing the rules and the expectations of the management team. And it really HR is very similar to legal. So my role is never to tell my client what to do. My role is to advise them of the risk and the options and what the law says. And it's not to help them make their best case for termination. It's to take the facts that I'm presented with and to say, all right, here are the various options and here are the risks associated with those options. But it's not necessarily to go on some sort of mission to dig up the dirt. And so I think this case really drew that out for me, that it seemed like HR was on the hunt for these pretextual reasons to fire her. And I think that probably put the HR team in a really bad position. So again, I go back to, what is your role? Your role isn't to try to create the facts in order to allow your manager to fire that person that they want to fire. Your role is to tell your management team what the laws and regulations require of the employer, what the risk profile looks like in case of a termination, and work with the manager to make sure that you're doing the right thing, not digging up some flimsy excuse that the court's going to see through from a mile away. So that was really one thing that this case brought home for me, is what is HR's role? Is HR there to do the bidding of management, or is HR there to advise how to make sure that we're staying compliant?
Teresa, I think too that we as HR professionals, there's an opportunity here to get some cover too, right? And when you're faced with this pressure, pick up the phone. Pardon me, my Jeff Umbo voice has made me hoarse. You'll pick up the phone and call outside counsel if you have concerns about protecting the company because you have managers or others placing undue influence on you to reach a result that may not be supported by your investigation. Perfectly appropriate to give someone a call, get a second set of eyes on it, and ask them to give their view of the facts and the law.
That is such a good point, Jeff. And I can't tell you how many times I've talked with my HR clients, and probably some of you in attendance have heard me say this. I get on the phone and they say, "Here's the situation," and I say, "I'm going to tell you what you already know," and they do already know. They know the answer, and they say, "Yep, I know, but I got to go back to the people I report to, and I have to say the lawyer said it." And sometimes that moves the needle, and we're here for you. Your lawyers are there for you if you need that kind of feedback. So that's a great point, Jeff.
Yeah, and I agree, and Angie just said it in the chat. Do not let your managers bully you into a bad decision, right? Because that's not that that's what it is, but that's kind of what it is, right? It's the manager saying, "I don't want to work with this person anymore. You find a way that I can fire them," right? And I get those calls too, and we say what we say and we give you your risks, and yeah, but we're not going to let you put us on the hook for a bad decision and making things up, right? Which is definitely what seems to have happened here.
So
Sarah, can you talk a little bit about documentation? And we've got a question in the chat too about note protection.
yeah,
Can you walk us through some of those thoughts?
yeah,
Yeah, I sure can.
I'm glad you saw that, Jeff. We got two questions. How did they get a hold of the notes? And how as HR can we protect our notes from a court? So Sarah, what are your thoughts
Yeah.
on that?
Yeah, and those two questions are, I'm going to tell you, documentation is a double-edged sword, right? So what ultimately happens is 9 out of 10 times there is a defense that the company can use to say, we were not necessarily aware of what was going on. We should not be held liable for it. As soon as we found out about this conduct, and the complaints, we initiated a prompt investigation and we took a remedial action. Now, what happens though when we use that defense is that, yeah, we have to turn over the notes from the investigation 99% of the time. Because we can't say we did an investigation and not share those notes to show the quality of the investigation, right? So a lot of times we are dependent on those notes. And so it honestly is better to focus on how to document correctly, um, and kind of avoid some of these things. Now, I will also say, just to the extent of how can we protect our notes from the court, if it truly is a case of, we probably want to protect these notes from the court, you draft your notes to your lawyers. So at the top, this is a communication to whether it's in-house counsel or outside counsel, that is who you're writing to. You're not just taking notes, for yourself. So if this is something that you truly want to be able to argue that the notes are protected, that's one of the best ways to rope them into attorney-client privilege. And then your counsel can decide if you get to an actual litigation, whether to invoke the privilege or whether to waive it. So that, yeah,
I suspect there was a fight in this case over some of these notes because if you ever read the case, the university's general counsel was involved in some of these meetings, appears to
yeah,
be. So I suspect that there was a fight. And the notes, interestingly enough, were not even examined or analyzed by the federal magistrate who decided and granted summary judgment in the first instance. And if we've got time at the end, we'll talk a little bit about that decision.
yeah, yeah. But you're right, Jeff. A lot of times notes are at the heart of a fight. In fact, I have a case right now where we're fighting over whether to turn over some notes from an investigation. And so it is something that ends up basically in the litigator's hands. So the best thing that you can do ahead of time, is to be proactive in making sure you're documenting accurately, that you're dating those notes. And I think it's also really important to emphasize this because I have clients call and say, "Hey, we want to terminate this person. And I'll tell you what, we don't have anything in the file. So what should we do? Should we start making writing things up that they did, in the past?" Absolutely not. That's the answer. We want those notes to be contemporaneous. So that's why we like to see them dated. We like to know that those notes were taken either during an interview or, with the employee, or they were taken, when the actual misconduct happened. We do not like notes generated after the fact. Those are not helpful to us, and they're actually can be quite harmful. So that's sort of key number one. And I mean, I don't know what you guys think about this, but takeaway number two, I might say in this case would be that, like, why is HR taking notes during meetings with counsel? Like, maybe you don't even need to be taking those notes, right? So that might be a time when you don't necessarily need to be documenting, because you've got counsel there and maybe counsel's documenting, and then those notes are a lot more likely to be privileged, right?
Yeah, Teresa, we talk often about the risk of retaliation, and timeliness and timing on this case, I think, led to some of the big issues related to the retaliation claim being reversed by the 10th Circuit. Do you want to talk a little bit about that?
Well, so I guess maybe I'll combine my talking points on timeliness with the talking point about retaliation. But here, first of all, let's talk about timeliness. The Walking Stick Dixon made a complaint on May the 4th, and she wasn't interviewed as part of her complaint until late July. Now, there was an intervening FMLA period in there that started in June, but, in a perfect world, she certainly would have been interviewed at some point in May from a timeliness perspective. And I've done lots of investigations, and sometimes they, turn into their own special kinds of monsters that take a lot of time to finish. So I definitely can sympathize with an investigation that takes, more than a few weeks to complete. But I think getting those investigations done timely is very important. And, I could see this whole case turning out differently if they had jumped on it in May before she went out on FMLA leave, because they would then have known the parameters of what she was saying that her supervisor had done. They could have interviewed their supervisor and said, okay, did you say these things? That didn't come out in the court filing, whether or not he really said these things. And remember when she made that Title IX complaint back in January and things got better for a little while? Maybe the same thing would have happened here. Maybe it all could have turned out differently if they would have jumped on that investigation a little quicker. Maybe the powers that be would have been tuned in to this pending complaint and not been so quick to terminate her. So that was kind of my thought from a timeliness perspective. And then from the timing perspective, and as it relates to retaliation, obviously, when you fire somebody soon after they file a complaint, you're going to run the risk of drawing a claim of retaliation. And here, the university wanted to focus on her May 4th complaint. But remember, she was interviewed in July, in late July, and that's when she gave the details about what her manager had done, and she was terminated within weeks of that interview. And so that timing, that close in time between her protected activity of complaining and then participating in an investigation, the closeness of the timing between that protected activity and the termination was a very important factor to the court. And they said, they really relied on that. So
I think
go ahead, Sarah.
Oh, I was just going to say, I think the other timing piece to me that's interesting is, if the main reason for her termination was that sort of alleged falsification of the time records, those happened well before, right? So you also have that delay in time between, okay, she falsified these timekeeping records, and then all these other things happened, and then you fired her for falsifying the time records back in, March or April. So I think that's another timing piece that just does not help the employer in this case.
And it was double jeopardy, right? Like, they already gave her the reprimand. They already gave her the official reprimand for the supposed time card issue. And then they circle back on it after
Yeah.
HR dragged through her attendance records to fire
Mhm.
her for that. And that was, remember, the main reason is what HR said. So it just all looked
Yeah.
very bad.
Yeah, there
Yeah.
were really dual investigations going on here, parallel investigations, and one of them probably should not have happened either at all or at the same time as the other one, and before they even completed the investigation into the complaint. Let me talk a little bit about performance evaluations. This is something that we deal with frequently, and made a deal out of it when Jeff Umbo was interviewing Teresa. But the manager here had said that she's meeting expectations, and that comes into play at several different points when we analyze these cases in litigation. But the 10th Circuit really focused on the box that was checked, and that prior to all of this coming up, the employee had been meeting expectations, and this has gotten more and more focus in the last 8 to 10 years. But in this case, it really made a significant difference to the Court of Appeals. The magistrate judge who decided the case in the first instance focused more on what Teresa was focusing on in her interview, and that the performance evaluations had pointed out that she wasn't perfect. She wasn't doing everything right. But at the end of the day, the 10th Circuit said, yeah, but you checked meeting expectations. So truth in performance evaluations, obviously a big deal. If she really wasn't meeting expectations, that should have been dealt with. You can surmise, and certainly the 10th Circuit did, about why it had been marked that way, because it was accurate at the time. Then the complaint came, then she began to be a bad employee. That's not a good set of facts. We've got a couple minutes left. Teresa, do you want to talk about retaliation a little bit more?
Yeah,
Or
so I just retaliation is the claim that always gets you, right? Like we see this time after time in case outcomes that proving discrimination is very difficult. It's very difficult to prove because most people are sensitive to discriminatory conduct, and they, assuming good intent, most people don't we don't want to think that they engage in discrimination. But retaliation, that'll get you every time, because everybody can relate to being accused of something and being mad about it. And here, look at what Dr. Reif said. He said these accusations of sexism and racism offended him to his very core. Obviously he was mad,
And
right?
I'm sure he said, "How can you possibly expect me to continue to work with this woman? I
Right,
can't," right?
right. So retaliation is where a huge risk lies. But just because somebody files a complaint, it's not a get out of jail free card. That doesn't mean they get to get away with everything. You can still enforce your conduct rules, your performance rules. You just want to make gosh darn sure you're doing it consistently. You don't want to all of a sudden be like, well, okay, now I'm going to start issuing a discipline every other day for this person because I need the documentation. You want to make sure that if you discipline Walking Stick Dixon for attendance, that every person who committed the same violation is going to get the same discipline.
Yeah.
So you want to make consistency is key. So it's definitely not, again, and I've heard a lot from HR professionals where they say like, oh, this person knew they were in trouble, they knew they were about to get fired, and they swooped in and filed a complaint. Not a get out of jail free card, but it's definitely a moment to evaluate and make sure that you're applying your conduct and performance standards consistently, but go ahead and do it. Go
Yeah.
ahead and apply them consistently.
And one more reason it's so important to have that documentation done contemporaneously, because if you really do have something in the works and someone then swoops in and files the complaint, it's super easy to say, oh, we've been working on this for a month. Here's the documentation, here's the meetings, here's, it's been in the works for a while. And I think that definitely also helps protect against that retaliation. At least it gives you a pretty solid argument if you wind up in court.
yeah, let me just finish up and say, we are going to send out some more detailed notes about these takeaway lessons as part of the materials for this last session. We'll get those out to you either today or tomorrow. And we're right at time. I just want to comment briefly, feel free to drop off if you want, about how this court case got to where it was and how it all ended up. So this is a pretty long, this termination happened in 2018. Pardon me. The case was finally settled, I believe, in April of 2025. This decision came down in January of 2025 from the 10th Circuit. The federal magistrate judge in Oklahoma who heard this case, and it's interesting that a magistrate heard it. I've been practicing in the federal courts for more than 30 years here, and I don't remember a time when both parties consented to have a magistrate decide a case like this. It just doesn't happen very often. We have our Article 3 judges who are appointed by the president, our 10th Circuit Court of Appeals who are appointed by the president, and federal magistrate judges who are terrific lawyers and judges, but they are selected primarily to work on discovery issues by the sitting judges in that district. And so it's a different level of judge. There's a different focus in their day-to-day practice. But in this case, for reasons unclear, both sides consented to the magistrate doing it. If you read the magistrate judge's opinion and the 10th Circuit's opinion, it's almost like they're talking about two different cases. And the three justices of the 10th Circuit Court of Appeals focused significantly on the timing and on these investigative notes and what happened after May, between May and August. What happened in that time period? The federal magistrate really didn't focus on that at all. He briefly mentioned these notes, but essentially said he couldn't really tell who wrote them or who they were referring to. I think the 10th Circuit out of hand said they're clearly referring to the plaintiff. I also want to talk about what the first time I heard this was in law school, and they call it gastronomical jurisprudence, meaning your decisions are sometimes based on what the judge ate for breakfast, right? So we're linked to judges and how judges decide cases. In this case, the three justices from the 10th Circuit that decided this case are all appointed by Democratic presidents. The gentleman who drafted the opinion is an Obama appointee, and the other two judges are Obama and Biden. And interestingly, two of these judges are from Kansas and have links here to Kansas, and one was a former justice of the Kansas Supreme Court. So it was a very, very good panel, as we say, for a plaintiff in an employment case to get this group of judges. And we can't control that, right? We rely on the panel that we get, but this was an interesting panel because it came at things maybe a little bit differently than a more conservative panel would have. I think we're done. Teresa or Sarah, any other comments?
My comments are, I think I got all your reasonable accommodation questions answered. I was trying to do it back and forth. If I didn't, email me. Please fill out the survey that you're going to get after this. We always look at those and we appreciate them. And then if you didn't get the materials, we're giving you the link here to get to the materials, and your certification information will be emailed after verifying your attendance. And if there are any questions or issues, don't hesitate to reach out to us and we'll make sure we get you taken care of. Thank you for attending ELI 2025. We really appreciate all of you so much, and we enjoy putting this on every year, and we hope you get some benefit out of it as well. So thank you so much.
Thanks, everyone.
Yeah, thank you.